Welcome dear learner, you are welcome on this Swayam course. I am your instructor and we are dealing with understanding competition law theory and practice. We are at the juncture of second week and under second week module 2 we are dealing with lecture 4 and this is session 4 of this particular module, and today we'll start with the journey from MRTP Act to Competition Act 2002. The objective of this particular session, what we are dealing with today's lecture, to discuss the limitation and criticism of MRTP Act, and yes, we will of course discuss the key features and the reasons for shifting of MRTP Act to Competition Act 2002. But before taking the criticism and limitation of MRTP Act, if you remember in last lecture what we have discussed, the rise of MRTP Act, what were the situation or what were the reason behind the enactment of MRTP Act 1969 and what were the key provisions or concept which was under the MRTP Act. That means in last class or last session we have discussed the key provisions of the MRTP Act 1969, and in fact if you remember in a summary what we can say again, the MRTP Act 1969 was the act to ensure the economic system of in India does not lead to the concentration of economic power into few hands. Toward this end, emergence of monopoly was in control and monopolistic and restrictive trade practices were prohibited. However, the MRTP Act did not apply to the undertaking controlled by the government which is owned by the cooperative societies formed and registered under the central or provincial state owned or controlled by the corporation. If you remember, there are certain specific provision or you can say the unique feature of the MRTP Act like restrictive trade practices, if you remember the monopolistic trade practices, unfair trade practices which were totally prohibited under this act. There were the provisions related to the commission which is known as MRTP Commission. MRTP Commission is a commission where any consumer can file a complaint and it is a non-judicial body under the MRTP Act and very efficient to investigate in any matter related to the curbing monopoly or if found any complaint regarding the any anti-competitive practices like whatever the not anti-competitive practices was the term, basically the monopolistic restrictive trade practices and unfair trade practices was the term which was used under this act, but MRTP Act, MRTP Commission was very efficient to deal with such matter. But yes, there are certain limitations, there are certain policies of that time where we have already discussed the Nehruvian policy, industrial policy. There were so many problems with regard to the market economy and competition regarding the competition policy of India. There were certain reasons when we are coming and we are dealing with the market position, the liberalization, open of the market, globalization period, industrialization of period and too much WTO GATT and so many international and national pressure and required of the economy, so that there was reasons from shifting of MRTP Act to Competition Act. So in today's lecture we will discuss what were the actual reason from shifting of MRTP Act to Competition Act. For this we have to discuss the limitation provision, restriction or the you can say the criticism of MRTP Act. So dealing with this, we are starting with the limitation of the MRTP Act in 1969. Many difficulties were faced by implementing the MRTP Act since its birth in 1969 in relation to the provisions which were considered generic, obsolete and insufficient in dealing with several other offending trade practices. Like if you see by reason, point to point, you can start with its scope. The scope was very much limited, the restricted scope you can say. The MRTP Act mainly addressed the regulations of monopolies and restrictive trade practices. leaving other anti-competitive practices unregulated. Two important areas of competition law that were not specifically covered were abuse of dominance and anti-competitive agreements. Effective regulation of different types of anti-competitive behavior was hampered by the narrower scope. The second is lack of clarity. The definition of anti-competitive agreement and abuse of dominance in MRTP Act were unclear, which caused ambiguity and legal uncertainty. Because there was no explicit rules or regulation, it was difficult to companies to know what they are doing would be illegal. Additionally, this ambiguity complicated legal and enforcement process under this act. And there are certain more reasons, like the remedies which is required for the provision, that was not a type of what remedies which was required or expected from the laws like the antitrust law or the others country antitrust law have the remedy. That means you can say the ineffective remedies are under the MRTP Act in 1969. There were few provisions in the MRTP Act to address anti-competitive behaviors. The Act mostly used cease cases to desist order, which were frequently insufficient to successfully discourage anti-competitive behavior. The Act's capacity to effectively address and prevent anti-competitive practices was undermined by lack of strong remedies such as fine or structural remedy. One more reason is like dominance in bad in and itself. That means if you see the modern act, competition law, dominance is not bad as per law. Today's in competition law, dominancy is not bad in either of law, rather the abuse of dominance is bad. But if you remember the MRTP Act, the provisions are like the MRTP Act state that all restrictive trade practices are anti-competitive and they must be registered. The MRTP Act views dominance as negative and is of itself. The abuse of dominance is what is deemed harmful under the Competition Act. That means dominance is bad in and of itself under the MRTP Act was a provision which restrict the competition sometimes. And restricted enforcement authority, whatever the MRTP Commission was of the nature of judicial body under section 45 of the MRTP Act, which we have already discussed in last session. But if you see in detail the wider scope and the wider lens of the commission, you will find that the regulatory body lacked sufficient enforcement authority. That means it was very insufficient on the parameter of enforcement. The authority on that means MRTP Commission under the MRTP Act. The Act's enforcement body, the MRTP Commission, had little power to look into anti-competitive behavior, set fines or apply real penalty. The Act's ability to ensure compliance and discourage anti-competitive behavior was weakened by restrictive enforcement capacity. That means what is the unique feature we have already discussed of the MRTP Act, that there was a establishment of commission which is known as MRTP Commission. MRTP Commission was a commission who was under the capacity to investigate the matter or to penalize even the thing and to provide the remedy if any act which is in contravention of the MRTP Act scheme, as if any person found guilty, what we have already stated in and discussed in the Cement Association case or the Bata case in last session. But in fact, if you see properly, you will find the remedies are not so wide. The remedies is have toothless because the enforcement capacity was not so good. What is required from at that time the as per the economic policy or as per the market economy, they are very incapable against the anti-competitive behavior in applying the real penalties or set fine. So it was one of the more reason because the enforcement capacity was not very much good what was required. So it was the reason, and we can say the limitation of such act. Again, not only there are certain limitation or restriction, there are certain other shortcoming, or you can criticize on that basis the MRTP Act. And the shortcomings is like the biggest shortcoming of MRTP Act was the inadequacy of MRTP Act to provide adequate remedy to the complainant, what we have discussed in the last slide, except for order directing a respondent to cease and desist from the alleged monopolistic, restrictive or unfair trade practices. The Commission could not impose penalty or breach of law. No other penalty or fine could be imposed. That means for imposing the fine, imposing the real penalty for breach of law, it was required that they have order. That means it was a very restrictive power of MRTP Commission. So on that basis, you can say it was the biggest shortcoming of MRTP Commission under the MRTP Act. Since 1970, the Act had been amended several times to suit the changing circumstances. However, of late, particularly after economic reform of early 1990s, it was felt that MRTP Act had become obsolete in certain respect in the light of international economic development and relating more particularly to competition law like cartel, boycott, refusal to deal, predatory pricing, bid rigging, abuse of dominance, etc. Arising out of the implementation of WTO agreement, and there was a need to shift focus from curbing monopolies to promoting competition. Consequently, the decision of the enact to law a competition policy was announced by the Finance Minister of India in the budget speech delivered on 27th February 1999. That means the shortcoming or the restrictive provision of the MRTP Act, you can say it lead to the enactment of MRTP Act. And the WTO agreement, what we have already discussed, this is not only the reason whatever shortcoming, because sometimes the provisions what we are added to the system is the requirement of time as per the domestic policy and domestic nature. But economy was not a feature of a nation which does not affect by the outer, that means by the globally. And Indian economy was very much hit by the outer, that means by the international norms or the global, because we are at the edge of the globalization, industrialization. There was certain WTO agreement and certain commitment towards the international document for under which we are required to enforce, and we have to deal with more comprehensively with these provisions like anti-competitive behavior or unfair trade practices. That's why we have to adopt the regulation which is to not only to curb the monopolies, which is for the purpose to enforce the or enactment of the Competition Commission of India, like the body there should be to investigate in the matter, and there was a requirement of time to promote the innovation, innovative technologies or consumer welfare, which is only possible by the adoption of new act like Competition Commission or the Competition Act 1999. That's why in the budget speech of 1999, the Finance Minister, while delivering his speech, announced the enactment of this act, that is modern law, modern antitrust law, that is Competition Act 2002. And if you see the speech, there is a paragraph from his speech itself, which is basically the statement of that Finance Minister delivered during the budget speech, and the part is, the Monopolistic Restrictive Trade Practices Act has become obsolete in certain areas in the light of international economic developments relating to competition laws. We need to shift out focus from curbing monopolies to promoting competition. The government has decided to appoint a committee to examine this range of issue and the purpose of modern competition law suitable for our condition. That means what we are discussing in this session is a journey from MRTP to Competition Act, and if you try to find out the basic reason from shifting from MRTP to Competition Act, or the journey which start with the MRTP Act and come at the end at Competition Act as the enactment as a tool, you can find the reason in this speech in a single line where the finance minister stated that we need to shift our focus from curbing monopoly to promote competition. That means the MRTP Act, which was basically focused on curbing monopoly, and the current act which is about the promote competition, this is like the school, this is like a jurisprudence, a thought. That means the journey from MRTP to Competition Act is not only shifting from one legislation to another legislation, it was like shifting from a policy towards an again policy, or towards from one school to another school, or adopting a new jurisprudence in economic law. And the new jurisprudence is that the innovative technology or promotion of competition must be addressed or must be focused. Only curbing the monopoly is not required. We have to address the issue, and we have to come with the system where advocacy is important, like competition advocacy, which is the one major fold of the Competition Act. So let's begin. We will discuss in another lecture. So currently in this session, if you see the journey from MRTP Act to Competition Act, or shifting from MRTP to Competition Act, this statement is very much important given by the finance minister while during his speech. Pursuant to such announcement, a high-level committee on competition law and policy under the chairmanship SVS Raghavan, which is popularly known as Raghavan Committee, was constituted by central government in 1999 to advise a new competition in the country. This committee was appointed with an aim to shift the focus the law from curbing monopolies to promoting competition in line with the international environment. The term of reference of the committee inter alia included recommending a suitable legislative framework relating to competition law. The Raghavan Committee report, which was submitted in 2000, made several key recommendations that shaped India's Competition Act 2002. And here have summarized some key recommendations for you, and you can see the detail of the Raghavan Committee report, which is a very good piece of document to understand the economic policy of India of that time and the reason from shifting of MRTP Act to current modern law. But if you see some key provisions and the recommendation given by the Raghavan Committee is like enactment of a new competition law. Raghavan Committee strongly recommend the repealment of the MRTP Act and enactment of the new competition law. The committee recommended repealing the monopolies and restrictive trade practices and introducing a new competition law framework for India. Raghavan Committee also recommend the establishment of a competition commission. However, if you remember, under MRTP Act, there was a commission which is known as MRTP Commission, but there are certain restrictions, there are certain limitations what we have discussed in today's session. But yes, if you see the recommendation of the Raghavan Committee, the committee stressed the need for an autonomous regulatory body, the Competition Commission of India, to enforce competition law, investigate anti-competitive practices and promote fair competition. Committee also recommended the prohibition of anti-competitive agreement and abuse of dominant position. That means the provision must be there so that it is require a new law, because we have already discussed the dominant position was bad under MRTP, but what Raghavan Committee recommended, not dominant position but abuse of dominant position. The committee recommended provision to prohibit anti-competitive agreement, cartel and abuse of dominant market position, aiming to prevent practices that could distort competition and harm consumer interest. Committee recommends some other key provisions like establishment of competition commission. The committee stressed the need of an autonomous regulatory body, the Competition Commission of India, to enforce competition law, investigate anti-competitive practices and promote fair competition. Prohibition of anti-competitive agreement and abuse of dominant position. The committee recommended provisions to prohibit anti-competitive agreement, cartels and abuse of dominant market position, aiming to ensure prevent practices that could distort the competition and harm consumer interest. Regulation of combination was the required at the time what it was felt by the committee, so that the committee suggested introducing a provision to regulate merger, acquisition or any other combination that may have an adverse impact on competition, ensuring the market consolidation does not harm consumer interest. Consumer protection. The committee emphasized the importance of consumer welfare, recommending that provisions to protect consumer interest from unfair trade practices, misleading advertisement and deceptive conduct. Committee suggests for a comprehensive law. The committee recommended a comprehensive law that would effectively address anti-competitive behavior and promote fair competition. Focuses on anti-competitive agreement and abuse of dominance. The committee highlighted the importance of curbing anti-competitive agreement and the abuse of dominant position by enterprises. If you see the report of the committee, that means the Raghavan Committee, there are so many certain, it is a big document. There are certain reasons, justification for these key component what we have dealing with today. If you see the following Raghavan Committee's recommendation, it was a recommendation not only in the interest of consumer but in the interest of economic policy of India. The economy of India at the time of the liberalization and globalization, it was the need of the time. That's why at the time government and the very much follow to the Raghavan Committee, and following the Raghavan Committee recommendation, the central government consulted all stakeholders at the time, even including the trade and industrial associations and general public, NGO and businessmen. The central government decided to enact a law on competition to replace the existing competition law, which was the MRTP Act of 1969, and which was primarily designed only to restrict growth of monopoly market with a modern competition law. And the central government introduced the Competition Amendment Bill in 2001. If you see the statement objective reason of the bill, that means what was the mentioned in the bill, that in the pursuit of globalization, India has responded by opening up its economy, reviewing control and resorting liberalization. The natural corollary of this, that Indian market should be geared to face competition within the country and outside. This is a very remarkable point. The objective of the bill was India is geared to face competition from within country and outside. That means now what we are focusing on the facing the current challenges, and challenges is like the competition. So the Competition Bill 2001 sought to ensure fair competition in India by prohibiting trade practices which cause appreciable adverse impact on competition in market within India, and for this purpose, the quasi-judicial body known as Competition Commission of India is to be created, which will enforce the provision of the Competition Act 2002. The CCI was further interested to undertake competition advocacy for creating awareness and imparting training on competition issues. And in the reference, the Competition Bill 2001 was passed by the Parliament in December 2002, and on 13th January 2003 received the assent of the President of India and was published in the Gazette of India on 13th October 2003. And some sections of the Act were brought into the force on 31st March 2003. The majority of other sections were brought into the force on 19 June 2003. So with this, what we take today, and that means what are the key what we have taken was today's lecture, that we have started with the MRTP Act, but we have shifted toward competition law, and the gap from MRTP to competition law is a journey with so many interesting events. And the basic reason from shifting from MRTP Act to Competition Act is certain restriction, limitation, and the inefficient remedy was provided under the MRTP Act, one side. Second one, that means you can say the first reason is incapability of the commission, that is MRTP commission under the MRTP Act. The second main reason was the global or globalization or liberalization or open up in the market. India is at the stage where it is required to open its market, that means the time of liberalization. And the commitment towards the international document, the WTO agreements. And on other hand, there is not only, which is required as per competition policy, monopoly, restricting monopoly or prohibiting monopolies on one hand, but India on that stage where it have to face the competition, not competition in the, that means in the domestic level, in national level, but at the world stage. So to promotion of competition is important. Facing of competition is important, that means at the from the private enterprises or private field, in fact, so that because MRTP Act is generally limited to the curbing the monopolies, but the requirement of the time is promotion of competition. So with this object, the promotion of competition is the one main and ultimate reason for the shifting of MRTP Act to Competition Act 2002. So with this, we will discuss the key feature of Competition Act 2002 in next session. Till for you, you are required to, and you are advised to go with the committee report what we have discussed today, and the reference is given under this session, that means on the slide the reference is given, so you may access. And for today, thank you very much.